All right, I've now started recording. I'd like to welcome everybody who's in attendance and everybody who will be listening to this particular recording. We are on week 9 of our online weekly lectures for CRW2601. Today we'll be covering study unit 10, a very important and a very involved study unit. And for this purpose and this reason, I will take the unprecedented step of affording you a break in the midst of this lecture. So in other words, I'll cover a certain portion of the study unit, and then I will give you guys a 10-minute tea break. And then you'll come back after 10 minutes so that I can complete the rest of it. As I have stated, it is a very involved unit. It covers concepts that have confused even judges. The example most recently being Judge Masipa, who was the High Court judge who sat for the Oscar Pistorius case. So we will be dealing with certain concepts that have even confused honorable judges like her. So please be vigilant in terms of listening carefully and following in the study guide as well. I would like to urge you to also write notes for yourself, or if you have questions that you want to put on the chat, please put them as well there. I'd like to acknowledge my colleagues as well who have joined me, Professor Molema, Professor Dean, Advocate Kumwenda, and Ms. Baloy. They are with us as well, so I'd like to acknowledge them in this platform as well. So without wasting any further ado, we will get into the actual lecture. We are on page 137 of your study guide. For those who have the guide before you, we are on page 137. But by way of recap, and this is an important recap because the previous unit actually laid the foundation for this particular unit. Firstly, as normal, we started on the 28th of April, covering chapters 1 and 2 simultaneously. And then in the next lecture, which was in May, early May, we began covering the concept of an act and omissions. That was week 2. Week 3, we covered definitional elements and causation. Week 4, we covered Unlawfulness 1, and that was covering the concept of unlawfulness and private defense. The following week thereafter, we covered Unlawfulness 2, which was necessity and the rest of the grounds of justification. And the following week after that, we began in Unit 7, covering culpability and the concept of criminal capacity. And week 8, we covered study unit, so not week 8, the following week thereafter, we covered study unit 8, which covered mental illness and youth. And last week, we began covering intention under the concept of culpability. In that respect, we introduced the two elements of intention, which were defined as intention comprises of a willing or the willing of a result with the knowledge or awareness of certain aspects. And in that definition, importantly, this on page 126 of your guide, I would urge you to just page there if you have the guide before you, page 126 of the guide. In the shaded block, we introduced the two legs or two elements of intention. The first being the willing of the act or the result. The second being in the knowledge or awareness of certain aspects. In other words, the accused has to commit the unlawful act being aware of certain important requirements. He or she must be aware of the nature of the act that he or she is performing. He or she must be aware that the type of act conforms with circumstances outlined in the definitional elements of that crime. And he or she must be aware that they are committing the unlawful act or the act concerned in an unlawful manner. So the awareness must also extend to the concept of unlawfulness. We return back to this notion of knowledge on page 132 of your study guide. So if you read from 9.7 onwards until 9.9, that's 132 to 134, you will see a repetition of that concept that the knowledge component or the awareness component must extend to the requirements in the definitional elements of the crime, the requirement of the act itself, and the requirement of unlawfulness. Now, when we begin studying at 10, we revisit this concept of what happens then if the accused acts under a misapprehension of certain facts. But before we get there, let's move towards the recap still, that we recapped or covered the three forms of intention, that is dolus directus, dolus indirectus, and dolus eventualis. Please note that if a crime requires intention, it does not matter which form of intention is established. In other words, there are no crimes that require proof of direct intention and nothing else. Or there are no crimes that require dolus eventualis and nothing else. The reason the courts emphasize dolus eventualis is that it is the last or the catch-all form of intention. If the accused does not satisfy dolus eventualis, then the accused will likely escape the crime requiring intention for lack of it. So we emphasize that it is important that you know the definitions of these three forms and that you are able to reproduce them when asked to actually write them down, or when asked even to answer a question requiring you to apply intention, you are expected to articulate the definition of that particular intention requirement that you are applying. Please remember that we are testing not only your knowledge, but your ability to apply concepts. So giving definitions or articulating concepts as they are provided to you in these gray blocks is very important and will help you to accumulate marks as well. And then after explaining that, we emphasize that intention, to establish the presence of intention, we must use a subjective approach. Now, a subjective approach means, in simple terms, that we are concerned with what X actually foresaw, what X actually apprehended in his or her mind of the circumstances. So that is the subjective approach. But in order to reach an outcome that X acted intentionally, utilizing the subjective approach, the courts start from drawing a baseline of what would generally be expected. What will generally be expected, having established the circumstances in that situation. then what the courts do is that they place themselves in the position of X with those established circumstances and say X in that position would have foreseen this. Therefore, X must have foreseen this, and by necessary inference, X actually did foresee this as a possibility. So in order to reach the inference of saying that we draw this inference as a reasonable outcome or beyond reasonable doubt that X did foresee that this circumstance or this consequence will result, and X did reconcile himself or herself with the circumstance or the consequence occurring. Now, going to Unit 10, we are now on page 138. We say under the learning outcomes of that you should be able to further demonstrate your understanding of the requirement of intention by expressing an informed opinion on whether an accused has made a material mistake, be it a mistake relating to the object, the chain of causation, the unlawfulness of the act, or the definition elements that excludes intention. You should also be able to demonstrate your understanding of Aberratory Actors by identifying an instance of Aberratory Actors, applying the concrete figure approach, as well as the transferred culpability approach to the facts of such a case, distinguishing between instances of Aberratory Actors and instances of error in objecto. Now, under 10.1, we recap this idea that mistake nullifies intention. But let me explain firstly the concept of mistake. If X acts under a misapprehension that certain facts exist in his or her mind, whereas in actual fact, those facts or circumstances do not exist or are not as he or she apprehended them, then we say that X acted under mistake. But not all mistake or not all situations in which X acts under a misapprehension affords a defense excluding intention. For that to happen, the mistake has to either relate to the nature of the act concerned, or it must relate to a circumstance contained in the definitional elements of the crime, or it must relate to the concept of unlawfulness. If a mistake or a misapprehension of facts does not relate to any of those, then X has acted under an immaterial mistake. In other words, under a mistake that is not material, or a mistake that does not matter for the purpose of excluding intention. Let me repeat that. Whenever X acts under any misapprehension of circumstances, X acts by mistake or under mistake. But the mere existence of a mistake does not necessarily mean or lead to the conclusion that X has a defense excluding intention. In order for that to happen, that mistake has to be material. And by material, we mean that it has to relate either to the nature of the act, it has to relate either to the circumstance or a circumstance articulated in the definitional elements of that crime, or it has to relate to unlawfulness. We give a few examples of what we mean by that. let's take the example of a mistake relating to the act. For the purpose of the crime of malicious injury to property, one of the elements of that crime is that there must be damage of property. Now, if X is fixing a car and does not believe or does not act under a belief that she is damaging the car, then we say that X's intention does not extend to the element of damage. So in that aspect, X would have a defense excluding intention if charged with the crime of malicious damage or malicious injury to property. Likewise, in the case, for example, of common law perjury, which some of you have covered already in CRW2602, it is important that X commit a false declaration. That is the nature of the act. X must commit a false declaration. If X is under the impression that he or she is making a declaration but does not believe that that declaration is false, objectively so, then it means that X's mistake does not extend to the nature of the act required. And in that sense, X does not have intention to commit common law perjury. Let us look at a mistake relating to the circumstances contained in the definition elements of a crime. Now, if we take the crime of unlawful possession of drugs, for example, which you've also covered in CRW2602, it is important that X must be aware that the product that he or she is holding or using is a drug that is prohibited by law, or either a dependence producing substance or a dangerous dependence producing substance as articulated in the definition of that crime. This is an aspect that is contained in the definition elements of the crime of use or possession of drugs, that the drug itself must be either a dependence producing, a dangerous dependence producing drug, and or so forth. Now, if X is under the impression that the product that he or she is holding is bicarbonate of soda or talcum powder, then X does not act under the belief or is not aware of an important aspect contained in the definition elements of the crime of use or possession of drugs. He or she is not aware that the product that they are holding or using or that they are in possession of is a dependence-producing substance or a dangerous dependence-producing substance prohibited by law. And the absence of that awareness is material because it relates to something contained in the different elements of that crime. And it will allow X to lack intention. Let's take another example of that which you'll come readily to understand. It is important for the crime of rape, for example, that X be aware that he does not have consent from the victim concerned, because the element of without consent is in the definitional elements of the crime of rape. So if X under the belief that Y did actually consent to the act of sexual penetration, then X's awareness does not extend to a component contained in the definitional elements of the crime of rape, that being the element of without consent. And the absence of that means that X does not act intentionally. Let's look at the element of unlawfulness. The most common situation here is if X believes that they act in private defense in a situation, meaning that X believes that they were faced with an unlawful attack against interests that deserve to be protected, and that the attack was commencing and not yet completed. Now, what if it happens, for example, that objectively speaking, there was no attack to speak about, but subjectively speaking, X believed that there was an attack upon an interest that deserved to be protected, which was commencing and still ongoing. In that situation, X would lack intention because her intention would not extend to the element of unlawfulness. X thought that she was acting lawfully. She was acting in private defense. That will result in X lacking intention for that purpose. Now, when we say on page 139 that mistake need not be reasonable, what we are basically emphasizing is that just as we determine intention subjectively, and we are not concerned about what a reasonable person would have thought, mistake also must be material but need not be reasonable. In other words, it is not necessary that the reasonable person in X's situation labor under the same mistake as X did. It need not be reasonable. All we are concerned about is whether, subjectively speaking, X operated under a mistake which is material and would exclude intention. So we come back to the concept of the material mistake on page 139 under 10.3, and it continues into 140 and covering the illustration on 141. We repeat the emphasis that for a mistake to be material, it has to relate to a requirement of the act, a requirement contained in the elements of the crime, or the unlawfulness requirement. Now, coming back to the concept of murder, which is the emphasis that I want you to keep in mind as we speak about mistake. From now on and moving forward, when we speak about mistake in this unit, we are focusing on the crime of murder, because murder consists of the unlawful and intentional causing of death of another human being. What if, for example, X thinks that the object that he is shooting at is an animal? Maybe X is hunting game, and X sees an object and thinks or perceives that that object is an animal or the game that he is pursuing. He fires a shot at that object, strikes it, and then upon coming close to that object sees that he actually shot another human being. X would be charged with murder, and the question would be, did X intentionally cause the death of another human being? Now, in such a situation, we say that X has committed an error in object or error in objecto. In other words, X acted under the misapprehension that the object was an animal, whereas in fact it turned out to be a human being. So X committed an error in objecto, or acted under error in objecto. The question then becomes, will that error in objecto afford him a defense excluding intention? For that, we have to look at the definitional elements of the crime of murder. It says, causing of death of another human being. The question is, did X's awareness extend to another human being, which is the articulation of the definitional elements of the crime of murder? Clearly, your answer should be no, because X acted under the misapprehension that he was striking at game, at an animal. So his awareness did not extend to a circumstance contained in the definitional elements of the crime of murder, being another human being. And because he lacked that awareness, that mistake or that error in objecto is material. And for that reason, X will not have intention and will escape murder on that basis. What if then, taking another circumstance, X wants to kill a certain person called Peter. X sees a figure, believes that it's Peter, fires at Peter, strikes that same object that he perceived to be Peter, approaches towards Peter, but realizes that no, it's actually James. It's not Peter, it's James. X has still acted under a misapprehension of the circumstances, but the misapprehension relates to the identity of the victim concerned. It's not Peter, it's James. So there is an error in objecto still under those circumstances. But the question now is whether that error in objecto affords X a defense excluding intention. What does the circumstance in the definitional elements of murder say? It says that the object must be another human being. Did X believe that he was striking and killing another human being? Yes, he did believe, and he did act under the belief that he was striking another human being. And that is sufficient for the crime of murder. Murder does not require that you kill James or you kill Peter. Murder only requires that you kill another human being. Murder, for example, does not require you to kill Riva Steenkamp. Murder requires that you focus and ask yourself, did X kill another human being? And X indeed, in our second example, killed another human being. And it is irrelevant whether the identity of that human being is Peter or James. So that form of error in objecto will not exclude X's intention. X will be guilty of intentionally causing the death of another human being. Those are the two examples speaking of the difference between a material and a non-material mistake. So we have covered these on pages 140 and 141, and we have spoken of error in objecto and have explained these concepts individually as we go along. Now, as you know, for the crime of murder, the definitional elements of that crime speaks of causation, causing of death of another human being. So does intention also require that X's awareness speak to the chain of causation? Yes, according to our courts, the chain of causation does matter. The chain of events that actually took place must not be materially different from how X perceived them or believed them to be. So let us look at this form of mistake. Let's take the examples that are there on 141. X sets about killing Y by pushing her off the bridge into a river, expecting that she will drown. In fact, Y is killed because in her fall, she hits one of the pillars of the bridge. So as you can see, there is a difference between how X perceived that Y would die and how Y actually died. X perceived that Y would die from drowning, but Y in fact was killed from hitting the pillars of one of the bridge before actually drowning. The other example that is provided there is X shoots at Y but misses. Y, who suffers from a weak heart and nerves, dies of shock. Again, we have a differentiation between how the actual chain of causation happened from what X perceived or desired that the chain of causation would take place. But the question is, do such deviations exclude intention? How serious or how severe should the deviation be? Let me take the example of two people going and performing a robbery. In the course of that process, going into the store, they carry guns, and whilst going about performing that robbery, the cashier is shot by one of them and dies from that, and they escape, or eventually they are caught. Now, let's say in addition to that, there was one who was in the car, the getaway car, and took them to the actual venue and was waiting for them to get away as well, and stayed at the car as well. So the question will be, for that individual who stayed in the car, did not go in, but knew that his co-associates had a gun, would that person be guilty of murder? Would that person also be said to have had intention in relation to the killing of the cashier? The question would be whether he foresaw subjectively the possibility that in going about the robbery, there would be a shootout, or there would be resistance to the actual robbery. And in the process of the shootout, someone would die. If he foresaw that and still reconciled himself with that possibility by going ahead, then that person does have intention in the form of dolus eventualis. But now let's say, for example, the shootout takes place, but the shot that killed the cashier is a shot fired by the security guard or by the intervening police officer who came onto the scene and tried to defuse the situation. In other words, the victim who died not from the shot fired by one of the robbers, but died from the shot fired by the police officer, as happened in the case of Lungile. Of course, that is a differentiation between what X would have foreseen, the causal chain of events taking place, from what they actually did, from how they actually did take place. But the question is such differentiation or deviation between what was foreseen and how it actually happened, would that afford X, who was the driver in the getaway car, a defense excluding intention? Well, that question was covered in the case of Hussen. In Hussen, interesting set of facts. We have X, Y, and Z who were driving a Ford Cortina. They were chasing somebody who was driving a Mercedes-Benz. And this Mercedes-Benz stopped at a certain stop station or robot. The Cortina came and stood right in front of that car, blocking the way forward. And then the other two assailants came out from the car, holding guns. The other one went to the driver of the Mercedes-Benz, punched that driver. And then what happened is that the victim mistakenly put his leg on the accelerator, and the car moved forward towards hitting the cortina. And the other accused, who was holding the gun and pointing it towards the driver of the Mercedes-Benz, jumped up and jumped towards he attempted to jump behind the cortina, or towards the boot of the cortina. And as he jumped, the gun fired. The gun was fired, or the shot went out and killed the driver of the Mercedes-Benz. Now, they were charged with murder, all of them, and it was the matter went on appeal because the accused, who was the driver of the cortina, was challenging whether he had intention to commit the crime. Then what happened is that the Supreme Court of Appeal decided that the gun was fired involuntarily by the individual. The gun was fired involuntarily by the individual who jumped behind the cortina. And the question was, did X, who was the driver of the cortina, foresee that the shot fired would be fired involuntarily in killing the driver of the Merc? And the court, the Supreme Court of Appeal, or the appellate division at the time, held that there was indeed a substantial or material difference between how the events occurred in actual fact and how X, the driver of the cortina, subjectively foresaw them happening. And on that basis held that such a deviation would exclude intention. So a mistake relating to the chain of causation, if it is material, if the deviation is material or substantial, will exclude X's intention. That is mistake relating to the chain of causation. So we distinguish on page 143 the case of Hussen with Lungile. As I gave in the example, Lungile is just a situation whereby the police officer shot or fired a shot towards the robbers, but his shot actually killed the one of the employees of the store. And one of the robbers said that, well, there was novus actus interveniens in that situation. Now, aside from the question of novus actus interveniens, we use Lungile to say, can we say that the deviation between what the accused foresaw things would happen and how it happened, can we say that that was material? And we have submitted that it's not material enough on page 143, as has happened in the case of Hussen. Now we are moving to the concept of Aberratory Actors, which is on page 143 of your guide. What does Aberratory Actus means? Aberratory Actus means the going astray or the missing of the blow. It is not a form of mistake. In other words, X in a situation of Aberratory Actus has correctly pictured what he or she is aiming at, but due to lack of skill, clumsiness, etc., misses that object and strikes a different object. Hence, we say it's the going astray of the blow. On page 144, we introduce you to the two concepts or the two opposite approaches in our legal literature which dealt with how to handle Aberratory Actors situations. The first situation was transferred culpability approach. Now, in this approach, basically, we asked the question whether X wished to kill a person. If X unlawfully intended to kill a person, even if that person is not the person who was actually struck and killed, then the reasoning is that because because X intended to kill a person, his intention to kill person A is transferred to cover his intention to kill the person who was struck by the actual blow. So it's a transferred culpability approach whereby we transfer the intention that X had towards A, and we say that X also had intention to kill B, B being the person who was struck. That is a form of a doctrine called Vasari in re illicita. Vasari basically said that if a person commits an unlawful act and wishes to achieve an unlawful consequence, then that person will be held to have had intention for any other consequence that followed from his unlawful act, irrespective of whether it was subjectively foreseen or not. So in the case of with transferred culpability, it was applied in the cases of Khoza and Kuzwayo, which were decided just before 1950. But later on, in the case of Msiza, there was a, shall I say, a minority decision by Judge of Appeal Holmes. It was a minority decision because it was not definitive of the decision in Msiza. The decision was held on a different basis by the majority, but the principles articulated by Holmes JA were never dissented to by the majority and have since never been discarded or disregarded by the appeal court. In fact, in the case of Thyssen and the case of Risen, which followed later on, the courts agreed with the approach articulated by Holmes in judging Aberratory Actors situations. Now, in those situations, Holmes preferred what we have articulated as the concrete figure approach, which means that we ask ourselves whether in relation to the person who was ultimately struck by the blow, did X have intention to kill that person? Did X subjectively foresee the possibility of killing that person? Did X reconcile themselves with killing that particular individual? If we cannot say that X had intention, at least in the form of dolus eventualis, in relation to that person, then we ask the further question, well, if he lacks intention, did X nevertheless act negligently? Would a reasonable person in the same situation have acted differently? And if such is the case, then X will be negligent and X would be guilty of culpable homicide. So we introduce the judging, or how we introduce the approaches on how to resolve a situation of Aberratory Actors on page 146 and 147. And then on page 147 onwards, we give you a couple of examples. This is in an attempt to help you understand the difference between error in objecto and Aberratory Actors, and most importantly, how do you apply the ordinary principles of culpability, meaning intention and negligence, to each of those situations. We have a number of these examples here. In the first two examples that are on page 148, There are examples of error in objecto, but there are examples whereby the error in objecto does not afford X a defense excluding intention on a charge of malicious injury to property. And the reason it does not afford X a defense on a charge of malicious injury to property is that X has still damaged property in each of those instances intentionally. So despite the misapprehension or the error in objecto, the conduct of X and his awareness extends to a component in the definite elements of the crime of malicious injury to property. Example number 3 is a situation of error in objecto whereby X operated under a material mistake. X thought that he was shooting and aiming at game, whereas in actual fact, or the neighbor's horse in this instance, whereas in actual fact strikes a human being. That error, as I articulated, is a material error in objecto because it relates to a component in the different elements of that crime. Example number 4 is an example of Aberratory Actors. This is the case whereby X is aiming at the neighbor's horse, but strikes a different figure. A different figure because he missed that the horse concerned. And ultimately, how one resolves that is that you apply the ordinary principles of culpability. You apply dolus eventualis. You ask yourself whether X subjectively foresaw the possibility that he or she would strike Z, being the stable boy. And did X reconcile himself with that possibility nevertheless and proceed? If X did that, then X would have dolus eventualis in relation to the person who was struck by that gunshot wound. Item number 5, example number 5 and 6 as well are instances of Aberratory Actors as well, because as you can see in each of those instances, the bullet misses. So this is to stress the concept that Aberratory Actors is a situation whereby X misses the blow, misses the object that he or she correctly identified, but strikes another object. So do not mistake an error in objecto with Aberratory Actors, as happened in the case of Pistorius, whereby Judge Masipa was very confused at some point about Aberratory Actors and error in objecto in her reasoning, and ultimately misapplied the principles of intention to that situation, because what she emphasized is that Oscar Pistorius foresee the possibility of striking Riva, and did Oscar Pistorius reconcile himself with that possibility? Now, that's a misapplication of the principle of dolus eventualis, because it is not necessary that Oscar Pistorius believe that the human being behind the door was Riva. If Oscar Pistorius believed that he was defending himself against an intruder, that intruder is still a human being. So his mindset was to kill another human being. It is an error in objecto in the sense that let's say we accept that Oscar Pistorius did believe that it was an intruder, whereas we know in actual fact that it was Riva behind that door. Then we can say that it was an error in objecto because Oscar Pistorius acted under the misapprehension that there was an intruder behind the door who was not Riva, but still fired shots and killed the individual behind the door who turned out to be Riva. According to the court, the lower court, he lacked intention, but the correct principles is that his mistake did not extend to a component in the different elements of the crime of murder. He believed that he was shooting and killing another human being. And under those circumstances, he did not, his error and objector did not afford him a defense excluding intention. Now, let's say Oscar Pistorius maybe had shot at that figure or had shot at that door and the bullet ricocheted and there was maybe another third person in the bathroom area and it struck that individual. That will be a situation of error of aberratory actors, not error in objecto, because there's a going astray or the missing of the blow. And in resolving that situation, you apply the normal principles of dolus eventualis, and if there's no dolus eventualis, of the reasonable person test for negligence. Now, this is where I've decided that I will give you a break because I'll give you a 10-minute break from now, and then we'll come back at 4:05 for the purpose of concluding the other aspects of mistake. So please do take this 10-minute break. We will come back at 4:05 to continue on page 150 with the other components of mistake. Okay, students, it's 4:05. Let us commence. We are on page 150 now of the study guide, and we are covering mistake relating to unlawfulness. Now, in this respect, please understand unlawfulness in two ways. The first way is a mistake relating to a ground of justification. This is where X believes that he or she is acting in private defense or necessity, or believes that Y consented to the act of sexual penetration, in which case it would be a defense, a case where X thinks that the lady gave consent, which was one of the defenses that Mr. Jacob Zuma gave in his rape trial. Ultimately, he was acquitted in that case on the basis that, objectively speaking, the victim did give consent. That is quasi. But so X may act thinking that he or she is covered with a ground of justification. That's a mistake relating to a ground of justification, which is covered under a mistake relating to unlawfulness. The other aspect of a mistake relating to unlawfulness is where X did not know that the conduct that he or she commits is actually a crime. Now you can imagine that there are a lot of statutory offenses that as normal lay individuals, we would not know that contravening them would be a crime. So as happened in the case of State versus Diplom, there was an individual who contravened a certain statutory regulation, and her defense was that she did not know that it was a crime. How did the court deal with that? That we will cover a little later as we go through this unit. Let's cover firstly the concept of mistake related to a ground of justification. Now, as we said, knowledge or awareness must also extend to the concept of unlawfulness. We have already covered the two other concepts that knowledge or awareness must extend to the nature of the act, and knowledge or awareness must extend to a circumstance contained in the deficient elements of the crime. So the third leg is that knowledge or awareness must also extend to unlawfulness. In other words, X must commit the act unlawfully and intentionally so. He or she must intend to act unlawfully in the sense that he or she must be aware, or at least must foresee the possibility that he or she cannot rely on a ground of justification. Now, the most common example is an example of putative private defense. This is where X thinks that they are facing an unlawful human attack against threatened interests, and the attack had commenced, whereas objectively speaking, in actual fact, there was no imminent attack upon X, but X acted under the belief or the misapprehension that there was such an attack and she was entitled to defend herself. Now, the leading case in this respect, which you also need to study, is the case of State versus de Oliveira. In the de Oliveira case, we have a situation where X and his wife lived in a suburb, but the suburb was an area which was frequented by robberies and house breakings. But their house was relatively secure and burglar-proofed. One Sunday afternoon, while he and his wife lay sleeping in their home, their employer who stayed in the backyard. Sorry, their employee who stayed in the backyard, his name was Vusi, came with a group of friends, and they wanted to get into the backyard, and to get to the backyard they have to enter the main gate and pass through towards the backyard. On this occasion, the door was locked, and upon hearing commotion from their upstairs room, X stood up, grabbed his gun, and without really giving a warning shot of any sort, fired 6 shots towards the individuals that were at the gate. 1 shot injured Vusi, and 1 shot killed one of Vusi's companions. So the unlawfulness of X's conduct was not an issue. The only issue was whether the state had proved beyond reasonable doubt that X had subjectively had the necessary intention to commit murder. So in that interesting case, the appeal court said the following, and I want to read this because it captures the difference between private defense and putative private defense. It was stated as follows. It subsequently transpired that the defense was rather one of putative private defense. From a juristic point of view, the difference between private defense and putative private defense is significant. A person who acts in private defense acts lawfully, provided his conduct satisfies the requirements laid down for such a defense and does not exceed its limits. The test for private defense is objective. In putative private defense, it is not lawfulness that is an issue, but culpability. If an accused honestly believes his life or property to be in danger, but objectively viewed they are not, the defensive steps he takes cannot constitute private defense. In other words, his conduct would be judged as being unlawful. However, his erroneous belief that his life or property were in danger may well, depending upon the precise circumstances, exclude dolus, in which case liability for the person's death based on intention will also be excluded. At worst for him, he can then be convicted of culpable homicide, full stop and close quotations. Now, in that brief explanation is the distinction between determining unlawfulness and determining culpability. And even in the situation where X relies on putative private defense, the question is, subjectively speaking, can it be drawn as a reasonable inference, the only reasonable inference, that X believed that he was under danger and was entitled to defend himself? If that was the case, if the court judging the state of mind of the accused reaches the conclusion that indeed the accused did believe that and it was honestly held, it would be the only reasonable inference to be drawn as to a state of mind, then X would have a defense excluding intention. However, under the circumstances, this is how the court reasoned in relation to Mr. D. Olivier. It said that the reasonable man in appellant's position. Now, when they use the word reasonable man, they are just saying if we place somebody in his position with the circumstances that we have determined, what would that person have thought? And then can we draw the inference that from this person's thought and belief, this is what X actually believed. So, quoting, open quote, the appellant did not testify as to his state of mind at the time of the shooting, whether or not he held an honest belief that he was entitled to act as he did, must therefore be determined by inferential reasoning. The reasonable man in the appellant's position would therefore only have known that there were strangers on the premises. He would also have been aware of the fact that the area in question was a dangerous one, where robberies and housebreakings were not uncommon. There was, however, no indication that any attack on the house or its occupants had commenced or was imminent. The appellant was in a situation of comparative safety in his bedroom, in a secure and burglar-proofed house, and armed with a pistol. In those circumstances, it is inconceivable that a reasonable man could have believed that he was entitled to fire at or in the direction of the persons outside in defense of his life or property, and that even without a warning shot. Close quote. Under the circumstances, the court held that the reasonable man in his position would not think that they were under attack. And furthermore, therefore, the question is, did his belief that he was entitled to act under private defense, was it an honestly or genuinely held belief? The court, having placed itself in that position of X where he was when he fired the shot, concluded that that would not be the reasonable inference to be drawn. And let me read the particular portion. Open quote, one would normally impute to a person in the position of appellant a state of mind akin to that of a reasonable man. In a given case, however, proved facts or circumstances may exist which would justify a different conclusion. In the present case, there were none. In other words, what the court was saying is that there was no other reasonable inference that can be drawn. A reasonable man in the same situation would not have thought that they were under attack. Therefore, X could not have honestly held, genuinely so, that he was under attack. And then the court went on to say this is so even if it is permissible to have regard to the evidence of appellant's marked dullness of intellect and the fact that he has not been blessed with more than a comparatively low level of intelligence. So even from someone with the appellant's limited intellectual capacity, one would prima facie expect a reaction different from that of the reasonable man, having regard to the particular circumstances of the present matter. In the circumstances, there was prima facie proof that the appellant could not have entertained an honest belief that he was entitled to act in private defense. The appellant failed to testify as to his state of mind and to refute this prima facie proof. His silence must weigh heavily against him. The evidence establishes that the appellant fired at least 6 shots in rapid succession into a confined area, a driveway. While aware of the presence of people there, 2 of them were struck and 1 was narrowly missed. Even if one accepts in the appellant's favor that he had not previously seen the people he fired at, he knew they were in the driveway. He fired in the direction in which they would have had to go if they had wanted to leave the driveway, which is the direction they could have been expected to take. He did not fire into the air. The injuries to the accused demonstrate that only one reasonable inference is to be drawn from the evidence. as well as the applicant's failure to testify, and that is he must have foreseen, and by necessary inference did foresee, the possibility of death ensuing to the persons outside, but reconciled himself to that event occurring. In the circumstances, he was correctly held to have had the necessary intention to kill in the form of dolus eventualis, and his appeal must fail. Close quote. So as you can see from a reading of that judgment, the court placed itself in the circumstances of the accused using the reasonable man objectively, so to speak. But the use of the reasonable man or reasonable person was used for the purpose of drawing inferences. Please note, this is a huge distinction from the concept of negligence. When we look at negligence and we apply negligence, we're not asking about inferential reasoning. We're asking about the conduct of the accused vis-a-vis the reasonable person. But in this instance, what the court does is that it uses the concept of the reasonable man for the purpose of drawing inference as to what that reasonable man in the same circumstances would have foreseen, and then moves towards there to say the only reasonable inference to draw is that the accused did actually foresee. So that I want to stress that this when the courts use the word reasonable man, make sure that you understand the context in which they are using it, and don't get confused between the concept of intention and the concept of negligence in this case. So in that case, the accused was found to have been to have had the necessary intention in the form of dolus eventualis, because when the court placed itself in the same position, it could not reach the conclusion that his life was under threat and he was entitled to act in putative private defense. That is the case of the Olivier, and we are now going to cover finally in brief moments mistake of law, which is on page 152 of your guide. This is the instance where we say that X was mistaken as to whether his or her conduct was a crime. So in the case of De Blom, which was decided in 1977, we have a situation of a woman who had contravened an exchange control regulation by traveling abroad with jewelry worth more than 600 Rand out of the country. This was a contravention of that regulation because that regulation put a prohibition as to the value of jewelry that one can travel with outside of South Africa at that time. Her defense was that she did not know that such conduct constituted a crime. The appeal court held that she had truly been ignorant of the relevant prohibition, upheld her defense of ignorance of the law, and set aside her conviction on the charge. If you look at page 153 of your study guide, we give an articulation of how the court reasoned its way to concluding that if a person at the very least foresees the possibility that if a person at the very least lacks foresight of the possibility that what they are doing is against the law, that person would have lacked dolus for the purpose of the crime concerned. And in the case of negligence, if a crime requires negligence as a form of culpability, then the question is, did the accused act as a reasonable person would have in the same circumstances? Would a reasonable person have made some sort of investigation as to what the rules are or what the law requires in such a circumstance, and did the accused conduct themselves as a reasonable person would have. If the reasonable person would have indeed investigated or would have taken steps to find out what laws govern their behavior, and the accused is found to have failed to do the same, then that differentiation means that the accused acted negligently, because the accused did not act as a reasonable person would have, and the accused would be negligent. So that is the explanation that is given on page 153 of the guide in relation to mistake of law. You are encouraged to try and practice as much as possible how to apply the principles concerned relating to mistake, relating to dolus eventualis, relating to Aberratory Actors, and please note, as I have stated, these the outline of these notes will be provided for you on my UNISA. So with that being said, that brings us to the conclusion of the actual lecture. And I will now proceed to take your questions. Just give me a minute. Let me just identify the hands. Okay, the first hand I see is BM Didi-san. Please note that your mic is unmuted. You can unmute for your, please unmute your mic from your side. You have been permitted to unmute your mic. Unmute your mic and ask your question. BM Didi-san, may you kindly unmute your mic from your side and ask your question. I have allowed you. Okay. I see we have lost that hand. The next person that I have enabled is Busisiwe Maria. Okay, Busisiwe. Yes.
Yes. My question goes back to the example. Okay, my question goes back to the example you made with regards to the robbery. Okay, yes. What happens now if it fires a shot up as a sign of a warning, but the shot ends up going through to Y, and then Y dies? Obviously, X does not know that the shot he fired up killed Y. So now my question is, which ground of justification would then X rely on?
That's actually a very, very good question, because the question then would be, when X fired the shot up for the purpose of giving warning, did X foresee the possibility that the shot would strike any person? And would did X nevertheless reconcile themselves with that possibility, including reconcile themselves with the possibility that they acted unlawfully? It will very much depend on the circumstances concerned, but I would believe that the court would say that X did not have intention to actually kill Y or any other person under those circumstances. But the question then will turn, X would obviously escape murder or assault, or depending on what the charge is. But the question will then go into whether X was negligent for the purpose of culpable homicide. And the question would be, did X act as a reasonable person in the same situation would have acted? That would be my answer to your question.
Thank you, Mr. Ramasa.
Okay. Apollos Hafina, may you kindly unmute your mic? Apollos Hafina. Apollos Hafina, may you kindly unmute your mic? Okay. You can speak. Hello, Apollos. I see your mic is unmuted from your side. We just lack audio. Hello.
Yes, please.
Hello.
Hello, can you hear me?
Yes, better now.
Okay. Sorry, I'm calling from Namibia. I just want to verify something.
Okay.
Just to explain for me again at the private defense and the putative defense, putative private defense, please.
Oh, okay. In short, Apollos, private defense is a ground of justification or a defense excluding unlawfulness. So if somebody is raising private defense, the question is whether their act complied with certain requirements that are set for reliance on private defense, and those requirements, if they are satisfied, then X would be able to rely on private defense, and his conduct would be lawful. In other words, he would have a defense excluding unlawfulness. But let's say X, for example, exceeds the bounds of private defense by overstepping in his act of defense, like goes overboard. Instead of merely averting the defense, goes extreme and overboard. Then he cannot rely on private defense in that situation, and his conduct would be deemed unlawful. But then the question would be whether in his mind, subjectively, did he believe that he was acting unlawfully? And then the question would be, does he have a defense excluding intention? And then that will then require the court placing itself in the position of X and drawing an inference of whether X had awareness that he was acting unlawfully.
Oh, okay, okay.
Yeah.
Oh, all right, thank you.
Okay. Please mute your mic.
All right.
Mandisa Ndauzana, please unmute your mic and speak.
Hello, Mr. Ramusa.
Hello, Mandisa.
Hi, everyone. And I hope everyone is taking care of this third wave. Hey, COVID caught me. I'm isolating at the moment.
No, you'll be fine, brother. You'll be fine.
Yes, thank you very much, sir. Mr. Ramosa, I've got a question on Visaki. One of these old cases, I think it's 2004, when the former rugby player Rudy Visaki mistakenly killed his daughter, shot her. But now I'm not understanding, because in my own thinking, because I even remember during the Oscar Pistorius case, they had many vets, Professor James Grant and other legal experts. They used to compare the case of Oscar and that Rudy Visaki. But in Rudy Visaki, he got acquitted. But yet, I think he said that he had intended to kill because he thought that the criminals were taking his car or something like that. but it was actually his daughter. So, and then he killed his own daughter. So, isn't suppose dolus eventualis should have been applied there in Rudy Visach? So now that's why I get this confusion, because okay, now to me I say okay, in Oscar now, okay, it's clear you intended to kill anyone. If you intended to kill maybe a criminal, but you intended to kill anyone behind the door. So that's why dolus eventualis. But now in Rudy Visach now, he intended to kill a criminal. So but that criminal was his daughter. So why didn't he get convicted? Because it doesn't matter now, because if it is not a criminal, it is his daughter that ended up dying from the bullet. I hope I make sense.
Yeah, no, you make sense. All right, I'm not familiar exactly with that case. I will have to do my homework to research on that and just read it myself to be able to give a firm articulation of how the court decided that matter. But from what you have explained to me, I can say that firstly, obviously, it depends on what charges he was facing. For starters, was it murder? Was it couple homicide? What exactly was he fully acquitted from? And on what basis? But what I can say is that in order to determine his state of mind at that time, the court has to place itself in the position of that accused person, and with the established facts around what actually happened, or what the surrounding circumstances, would have to draw the inference that a reasonable man or reasonable person in that same situation would have foreseen this or would have been aware of this, and therefore was this the only inference that can be drawn as to what Mr. Visagie actually foresaw or actually was aware of? Can the court draw the only inference that the accused did foresee that the person that he was firing at was a robber, or somebody who's come in to commit housebreaking? So I think perhaps much will revolve as to what the circumstances of that case were and how the court would have deduced the inference to be drawn under those circumstances to be.
Okay.
Does that help?
Yeah, it helps. Can I just send an email if I get my ducks in a row with that case? Maybe once you have you've had a look, and then maybe you can send me an email reply back.
Yes, also, I would appreciate that.
Thank you very much, Mr. Ramos. And last one, can I just ask? It's a quick one. This one, why it looks like to me courts draw a very bad inference when a witness to a murder or an accused to a murder doesn't take a stand, yet relies on one of a ground, like relies on mistake or error in objector or one of the other grounds. Because I saw in one of the cases that you had said the court was very hard on that, or was very harsh on that person to say that. Okay, but yeah.
Okay. This obviously ventures into the law of evidence, but let me explain it for you to give you a simple answer. Is that when an accused elects not to testify, it's always a risky, election to take for an accused person, because if the state manages to present evidence that establishes a prima facie requirement or bar that requires a response, evidentially speaking, from the defense, and the defense chooses not to rebut that evidential burden, then the court has to work with the evidence that has been presented to it, and by natural inference will have to draw the conclusion against the defense under those circumstances. Does that at least help you understand why evidentially speaking, an election not to testify may actually work against you?
Yes, Mr. Ramosa, thank you very much. Thank you very much. It's just a
Okay.
highlight. It helps.
Okay.
Thank you very much.
Okay, Nkosana Uluva, can you unmute your mic? Nkosana? All right. Let me move on to Petile Mtenjani. Can you unmute your mic from your side? Petile?
Yes, I'm here. Hello.
Yes.
Okay, I am a bit confused. On page 149, example number 5, right? That was
Yes.
an indication of Aberratory Actors, right?
Yes.
Okay, now we move on to page 150. Page 150, mistake relating to a ground of justification. I'm trying to clear the confusion in my head, so I just need a confirmation if I'm correct. So basically here, the ground of justification and what was that? Aberratory Actors. Aberratory Actors. It's two different things. These two examples set here, these are two different things, right?
Yes, they are.
It doesn't necessarily mean the example on page 150 is again an example of Aberratory Actors. Am I correct?
Which particular example are you referring to?
Oh, sorry. The example about the lady who mistakes her husband for a burglar who is a well-known rapist in the neighborhood, and then she shoots at her.
Yeah,
And
no, that is not Aberratory Actors, and
okay,
let me help you understand why it's not. Maybe let me enlighten you by asking you a question.
Okay.
Did the lady in the example mistakenly identify the burglar?
Well, she thought there's a burglar in the house.
Yes, you are right. She acted under a mistaken impression. So we do have a situation there of error in objecto. But the question then becomes, the further question would be, did the lady miss the object that she was aiming at?
Sorry, can you repeat that? Did the lady?
Did the lady miss the object she was aiming at?
No.
No, she didn't. So there's no missing of the blow. There's no going astray of the blow and striking someone else.
All right. So where the aberration is, it focuses on the missing of a blow. That's
yes.
it. I should
yes.
just catch it there.
Aberratio is the diversion or missing of the blow.
Okay. All right. Nyabonga, thank you so much.
Pleasure. Please mute your mic.
Oh, yeah.
Walter Kaba.
Thank you, Mr. Ramoso. I just want to understand, is there a difference between a reasonable man and a reasonable person? And either of the two, is there any of the two a fictional character? I don't know if my question makes sense.
Right. Thank you for asking me that question. There's no distinction. In fact, I think the concept reasonable person is a concept that is accepted as the modern way of saying it, because reasonable man has got connotations of being gendered.
Okay.
You know, so it's best to say reasonable person.
All right.
That's the modern way of saying it. It still remains a fictional character that is used to portray the standard of the law.
Okay. Can I just ask a follow-up question on that fictional character?
Yes.
Yeah, I read somewhere that the whole point of inventing this fictional character was that she or he should not share the viewpoint of a judge. Now, when and I've had a number of cases that we've dealt with today, the ordinary man and the way the jurist would think or the judiciary would think, ordinarily it will differ in viewpoint. Where do we strike the balance there? I think it was Lord Roger who argued that the whole point of inventing this fictional character, the observer, is that he or she does not share the same viewpoint of a judge. But now, in all the cases of law, it is the judge that acts as this fictional character or the observer. I'm not sure if I make sense with that question.
Okay, I think you'll have to give me context as to the quotation that you are referring to, and what the context was there.
Okay. The context in general was about the question of the appearance of bias and the fair-mindedness of an informed observer, and of course, biasness. The test of it in general is about this reasonable man or reasonable person, which is a fictional character who is an observer of the impartiality of someone who adjudicates. So when you, for instance, in the case of Jacob Zuma and state capture judge Zondo, advocate, I just forgot his name, when they were arguing about the recusal of Judge Zondo, one of the things that he was saying is that there seemed to be a misbalance on the judge being the judge for himself, on a basis that the standard that is used to evaluate this fictional person it's shared with the viewpoint of a judge against a layman in the form of Jacob Zuma, who's not a legal person. And that is the context at which this observer would have been argued by Lord Roger that the observer, the distancing the observer from the ordinary person should be the standard as opposed to the shared viewpoint of a judge.
Mr. Qaba, thank you very much for giving me that context. That context was very, very important. The test for impartiality definitely is, as used and adjudicated, is the reasonable observer. And there are criteria for judging impartiality. And the test used by the courts is that of a reasonable observer adjudicating or testing whether there is bias on the point of the judge concerned. That is a different test and a different approach altogether. And is used to judge cases or arguments of recusal. So as you can see, the word reasonable and reasonableness is used at various points, depending on what purpose it is used for. So please don't confuse the use of the reasonable person in the instance of determining negligence, with the reasonable person in the instance of determining what an inference of subjective intent or perception would be.
Okay.
Okay, is that clear?
I will digest it.
Yeah, no, no, hence I say you have to look at the context of where reasonableness is used. But generally speaking, reasonableness is used as a measure to determine what would be expected by society.
Yes.
Yeah.
Okay.
Am I making sense? Yeah.
Yes, I have a lot of questions, but let me digest the point and then I'll take it further when we meet again. But yeah, I have a number of questions flowing from your comments, you know. Yeah, but I'll let me digest it. That's why I commenced by asking if there's a difference between a reasonable man and a reasonable person. And if both are fictional characters who are supposed to be observers on a subjective assessment. Of course, I take into consideration the context of the question of law at a particular instance, but the test of reasonableness, which is rationality and proportionality, in my view, would have been applicable in both the circumstances. The extent at which I make this point is that the evaluation of this observer, from the argument of this Lord Roger, is that it was invented not to share the same viewpoint of a judge. Now, if a judge has to evaluate me as a layperson in what I have done in a particular situation, but look with his perspective, with his viewpoint, and neglect that I am just an ordinary person who arguably would not know these things that he would have deemed to be reasonable. What then do we say in that situation? That is all that, because if you evaluate my reasonability and in a criminal context, will that reasonability be beyond reasonable doubt, or else you are subjectively assessing my perception in a particular situation?
All right, let me come there to rescue you, Mr. Kaba. I think that's why I say it's important to limit and understand where the concept of reasonableness is used or utilized. The context is everything.
Yes.
Please make sure that you don't bring matters relating to administrative law or constitutional law into the aspect of criminal law. If I'm making sense, you know. So
Yes.
so when it comes to matters of bias, we are looking at matters of the law of evidence. We're looking at matters relating to constitutional law, admin law, where a lot of the word reasonableness and reasonable are utilized, but they are utilized as yardsticks.
Okay. Okay. Sorry, sir, you are breaking.
What? Yeah, there was, hello?
Sorry, sir, there was no sound for some time when you were making the last part of your point.
Okay, no, I was saying in short, it depends on the context in
Okay.
which reasonableness is used. Yeah.
Okay. All right. Thanks, sir. Thank you.
Okay. Please mute yourself. There are only 2 hands that I see here, and I'm going to try and squeeze them in these last 5 minutes. Mr. Senzeni Ngubeni. Mr. Senzeni Ngubeni, please unmute your mic.
I was so happy and enlightened and very much impressed about the way you explained the Olivier, what case, yeah, around the issue of private defense or justification. My plea, sir, to you is that I've missed quite a lot of these lecturers, and when you read the textbook or the study guide alone, to a certain extent, some of the things you don't understand as you explain them here. Is it possible that you can be able to send us, or in particular me, even the previous study units recordings? Because to listen to them, unlike reading alone, there is quite a huge difference. I've seen today when you were even explaining some of the concept. You know, as when you go to the study guide, it becomes so much clearer, unlike when you are sitting in your corner reading alone. That's my plea and that's my asking, but thank you very much. To me, you were so loud and clear. Thank you.
Thank you very much, Mr. Ngubeni. I am very humbled by that comment. All the recordings of the previous units are under announcements on the My UNISA site. So if you go to the module site and scroll down under announcements, you will see the recordings for each week combined with the notes concerned. What I've been thinking as well is that I can even try to upload the links for each recording under the discussion forum platform for each unit, because as you go under discussion forum and in particular ask your lecturer, you will see that I've partitioned each unit. So if you have questions for each unit, you are welcome to post questions right there. And what I think I'll do is that I'll actually go and copy each link of each unit's recording and repost it under each unit, so that you can go directly to those units if you're looking for a particular recording. Would that help?
Quite a lot, Mr. Rebelang, quite a lot, and that would really, I was about to send you a private email to request for that, but as you will be doing that, it will help quite a great deal. Thank you, sir.
Okay, no, it's a pleasure. Can I take the last person, Mr. Christian Beki Zungu?
Yes, thank you, sir. Only 2 minutes left. Thank you very much. Just have a question. Yeah, there was an incident, I think it happened last year, if I'm not mistaken, or 2019, where the police were following the information of most wanted suspects. And there was, I think, a misidentify of the motor vehicle, and they end up shooting at the innocent couple, and they died on the scene. So I just need to find out which ground of justification they can rely on. Is it area on a chapter or something else?
Okay, as you know in this, hello, can you hear me?
Yes, I can hear you.
Okay, did you want to follow up on something? I may have cut you.
No, I'm done with that question. The second question is, I sent you an email yesterday with regard to the assignment 1. There was an inquiry there. I don't know if did you get that message?
All right, let me answer your second question first, and I think I will answer it under general to say that We are receiving a lot of inquiries via email from students questioning their assignment marks, seeking reviews, seeking feedback. We have been fielding those at least for the past couple of days now. So if we haven't gotten to your inquiry, despite you having sent it, we ask for your patience because there are so many that we are so swamped. We have at least, I can confirm to you, we have over 11,000 students registered just for CRW 2601. It really is a huge challenge. So we will get to you. We are taking every query seriously. So we really plead with your patience and appreciate that you have stuck with us and you have consistently stayed with us. We appreciate that very much. I cannot answer your specific question, Mr. Zungu, because I would need a bit more information as to the circumstances that drove the police officers to fire a shot. Can I suggest, in the interest of time, if you can send me an email around that particular circumstance? Can you do that?
Okay, I'll do that, sir.
Okay. No, I appreciate that. And I want to just thank everyone who spent their time. I know this one was a lengthy lecture. It covered really difficult concepts. For those that have posted comments, questions or queries under the chat, please rest assured that I will get to each of them, as many as I can, to answer your particular questions. I just plead for your indulgence to give me at least 2 days or so to cover that. I'll also utilize the weekend where possible. But thank you very much for your attendance and your patience. And we will meet each other again next week, Wednesday, when we cover the concept of negligence, which is study unit 11. Thank you, and have yourself a good day. Yeah.
Thank you, sir. Bye.
Thank you.
Thank you. Thank you. Thank you. Aberratio. It's this Aberratio. Aberratio. I want to be Latin now.